Cardozo law professor Deborah Perlstein, thank you so much for your time tonight, Professor. Now, the former president's legal team argued at length today that President Trump's speech January 6th was protected free speech under the First Amendment. Do you feel that they made that legal case in your mind?
So the legal case is interestingly rejected by lawyers on both sides of the aisle. That is to say, the notion that all speech is protected by the First Amendment, even the speech of the president who has a constitutional duty to take care that the laws are faithfully executed, is a constitutional argument that's never really been made before. And you have prominent lawyers, both Democrats and Republicans, who have said it's not really supported by the Constitution. Just as the Supreme Court has long said, you can be prosecuted if you yell fire in a crowded theater, if you are actually actively endangering people. That same standard at a minimum applies to the president. But in fact, the president has a higher duty than most Americans, than all Americans, to, as the Constitution provides, take care that the law is faithfully executed. And if he had been the fire chief in that circumstance, he would have been fired. He would have lost his job. And this proceeding is not about depriving the president of his liberty. It's not about depriving the president of any property. It's simply about whether or not he deserves to hold the job or a job of public trust. And that's a really quite different question from the question that the First Amendment in the criminal context is designed to protect.
Now, if the Senate does convict, there's been a lot of discussion about barring the former president from future office. Majority Leader Schumer has not ruled out invoking the 14th Amendment. Has that process been used before, and is that something that could happen really under the Constitution?
So Section 3 of the 14th Amendment does say, and was adopted immediately after the Civil War, and it does say that those who have carried out an insurrection against the government of the United States can be barred from holding an office of public trust in the future. It was used in the context of the Civil War to go after the insurrectionists, to go after the Southern rebels, to prevent them from taking part in the new federal Congress after the war. It has not been used at all in the modern era in this way. So there is a significant open constitutional question if it can be applied in this setting, and if so, how. One of the ways in which it might actually eventually come up, whether or not Congress attempts to invoke it now, is if the president, the former president, ever does try to run for office again and get his name on a ballot, you may well see legal claims that say he should be barred from running again pursuant to the 14th Amendment. Now, whether or not that succeeds, either if invoked in court or by Congress in the first instance, is something that we've never faced. It's something that the courts have never decided before.
And it'll be interesting because on that night, Senator McConnell called it a failed insurrection. So still a matter, I guess, of semantics and by definition if it was an insurrection or not. Professor Perlstein, we thank you so much for your time.
Thank you.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.